Welcome to Audit Trails. Today we'll be discussing about ISA 250, that is non-compliance with laws and regulations. Now if I present you with a situation and tell you that you are an acting auditor for a client and you find some non-compliance with any law or regulation. Now you will want to talk about this or bring it to the notice of the management so that either they can rectify it, or there could be a situation when you might feel that all the facts are pointing towards an intentional non-compliance. So in any of these cases, the first thing that as an auditor, at whatever level we are expected to take is to always document our work. So for such suspected non-compliance or maybe a proper non-compliance as well, the first thing that as an auditor you will have to do is to document your findings and then discuss this matter with the management. Now, as an auditor, you are expected not to take everything on its face value and always use your judgment. So, in this matter as well, you will not take all the facts and information provided by the management on its face value. Therefore, you will go and have a search of your own and try to obtain more information regarding the suspected non compliance. There could be some certain situations when the statutory duty or the public duty of the auditor will simply outweigh the confidentiality agreement between the auditor and the client. Now, in those circumstances, the auditor will have the duty to purposely report this matter to the relevant regulators or the authorities. Now, for disclosing this matter to a third party, the auditor will also have to seek legal advice from appropriate legal team as to how to proceed and in what steps should be performed so that the auditor purposely and professionally deals with this matter. Confidentiality. As I've already told that in certain situations such as maybe suspicion of money laundering or maybe any other illegal activity, the auditor will have a statutory or a public duty to disclose this matter to the relevant authorities, to the other legal system, and for that there will be a breach of confidentiality agreement between the client and the auditor. But this breach would be absolutely necessary, and if not proper steps are taken, then the auditor will be at fault as well as the client. So for that, the auditor will have to seek legal advice as to how to proceed now, whom to contact, and what should be the steps that should be taken to further resolve this matter. These breaches or non-compliance will also have impact on financial statements. That is, maybe they will lead to some misstatements in our financial statements or non-disclosures to our notes to accounts. Maybe our liabilities could be understated, assets overstated to portray a better financial position. Maybe when this non-compliance is intentional, or there could be manipulation of profits as well. So all these factors will have to be taken account and then dealt with properly going forward. Now, as an auditor, when you have once found out regarding any non-compliance or even if you suspect some non-compliance, there will always be question regarding the integrity of the management, and because of that the level of the risk with the particular engagement will also change and jump to a higher level, and the level of professional skepticism which now will be expected from the audit team will be much higher. Therefore, all the evidences which are gathered from the management, such as the written representations, will now have to be more carefully scrutinized because they could be subject to manipulation and biasness from the management. In extreme circumstances, when the auditor feels that now there will be a question regarding the reputation of the audit firm, or maybe to protect himself or the audit firm from implications of any future legal case, the auditor can always seek withdrawal from the engagement, but that is in extreme circumstances only. The next step will be to discuss and communicate this matter to those charged with governance. Now, it doesn't matter whether you feel that the non compliance was intentional or unintentional or a genuine mistake, and maybe the management has rectified their mistake and now the non compliance does not exist. The matter will have to be communicated to those charged with governance. If the non compliance still exists, the auditor will go and request those charged with governance, that is the board, to make the relevant disclosures to the authorities. If the board fails to do so, then the auditor will be compelled to make disclosures himself. And in some cases where auditor suspects that maybe the board is also involved in that intentional non-compliance, then the auditor will have to take up this matter with the higher level of authority, that will be maybe the the audit committee, or maybe any other specific committee.